When the train come in the station, it had two lights on behind. The blue light was my baby, and the red light was my mind. All my love's in vain. When the train left the station, I looked her in the eye. When the train left the station, I looked her in the eye. I felt so sad and lonesome that I could not help but cry. All my love's in vain.
All right, what was your website's? Get my speaker working here. That's WillPWilson.
Well, my main website is named after my name, Louis Ewing, and it's spelled L-U-I-S-E-W-I-N-G, louisewing.com.
Yep.
And there's an index there for free flyers on many different subjects. I also have Ultimate Users with an S on the end, like Ultimate Fighting. It's ultimateusers.com, and you'll see a picture of the White House covered with marijuana plants. And then I also have cpsexposed.com, and that's the Child Protective Services, cpsexposed.com.
Okay, but wait a minute. The Ultimate User. Oh, excuse me.
There's S on the end. Ultimate Users.
That's right. Got it. R. Now. No.
And for those who want my email address, my three main email addresses are all starting the same: RCW Codebuster. RCW is the abbreviation for Revised Code of Washington, and it's spelled just how it sounds: RCW CODEBUSTER. And I have RCW Codebuster at AOL.com, Yahoo.com, and Gmail.com.
Got it. All right. This is AllDayLve. I'm WillPWilson. If you get my microphone up all the way here, so you can hear me. Hi, everybody. I think I can hear me too. Anyway, it's AllDayLve and WillPWilson, and thanks for watching today. This is Louis Ewing, a highly recognized tribal lawyer, and you're a judge as well, right, Louis? This is, by the way, this is
No, I'm not a judge.
You're not. Okay.
I'm lead counsel for the Kikialis tribe, which currently is not a, quote, federally recognized tribe, but it has been formally recognized by Senator Mary Margaret Haugen, who made a presentation to the legislature some years back. And the Kikialis tribe is currently trying to get placed on that list. There's a list on the Code of Federal Regulations, the CFR, that lists all the tribes that are federally recognized and eligible to become federally recognized. And apparently, people in Homeland Security and also in conspiracy with the Attorney General's office is trying to interfere with our application to become placed on that list as a federally recognized tribe, which is illegal because our tribe is specifically listed in the Point Elliott Treaty. And so that's a contract that's binding between the United States of America, Congress, and the Kikialis Indian tribe, which the Kikialis tribe is a subset of the Swinomish Indian tribe. And our tribe actually basically owns the Klamath River and like the Camino Island area, but the property was stolen from our tribe and we were not given reservation land. And of course the white man is going to try to fight to, rip us off and not give us our land. And so it's going to be a court battle sometime in the future probably over that.
No kidding, yeah, I'm sure. What about jurisdiction like judicial jurisdiction? There's 460 tribal courts in North America, right? Something like that. I believe.
I'm not sure of the amount. I think it's over 500 actually.
Is there right now? Okay. I mean, we learn as we go. But in the same sense, we're finding that our own judicial system has failed most of America. As you know, I've done quite a number of TV programs on the psychotronic.
Well, we don't really have a judicial system, okay?
Yeah, let's say the least.
No, we have a corporation pretending to be our government that's combined all three branches into one. It's called the executive branch, and the executive branch. So when you talk about all judges or attorneys are members of the bar, and every single prosecutor is an attorney who's a member of the bar, and every lawyer in the yellow page or attorney in the yellow pages is a member of the bar, and this group of people, or ilk of people as I prefer to call them, they've infiltrated all our state legislatures. There's at least 50% of the Washington state legislature, for example, is attorneys, and they're in there basically in criminal conspiracy committing misprision of treason, and they're tinkering around and playing games with the statutes like a private steering committee and adding a whole bunch of crap to our laws, and every year our law books become more convoluted and more hard to comprehend, and it's all written with the purpose to oppress the people and basically to rip the people off. A perfect example I can give you is the Code Revisor's Office. They're made up 100% of Washington state bar attorneys. At the end of the legislative session, they go over to the legislative offices and they say, okay, children, you had fun playing house and pretending to pass laws. Now give us those law books. And they gather up all the session laws, the Senate bills, and the House bills. And these criminally corrupt attorneys who are members of the criminally corrupt Washington State Bar Association, okay, they go back to the Code Revisor's Office and they close the doors and lock the doors behind them. And they get out their pencils and erasers. And they omit complete words, sentences, and paragraphs from the statutes, and they add complete sentences and paragraphs to the statutes. They put ors in place of and, they put ands in place of ors, they put commas in between things that don't belong, they split the statutes up into different sections and all of this was never authorized or approved by the Washington State Legislature, including, folks, I'm going to reveal to you a big traffic scam I just discovered. / failure to pay. In the statutes regarding authority to suspend a driver's license, there is no legal authority. The legislature has never passed it authorizing the state of Washington or any other state, they're probably all doing the same thing, that allows the state to suspend your driver's license for failure to pay a ticket. I call it the traffic scam. This is illegal. If you get a civil infraction for speeding, running a red light, improper turn, that is frozen in time, period. A civil infraction is always a civil infraction. The penalty says civil infractions, the only penalty is paying a fine. That's a civil infraction. It's a non-jailable offense. It's a non-arrestable offense. So, by the mere lapse of time, these people, the criminally corrupt prosecutors and judges, let me tell you, the judges are all lying to you, okay? All the judges and prosecutors are lying to you, and the prosecutors intentionally mistraining their police chiefs, the county sheriffs, and the state patrol to believe that the computer says your driving license is suspended, the computer says this and that, and then the prosecutor says, well, so-and-so is charged with driving while suspended, and then the judge says, how do you want to enter a plea of guilty or not guilty? Now, the judge is the criminally corrupt / blank, 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 that is basically the thief wearing black Jesuit robes of treason who inputs the information into the computer, or the court clerk does it. Court clerk does everything at the instructions of the judge, and they know that they're committing crimes. They put the information in the computer. So-and-so didn't pay their ticket on time, so we're suspending your privilege to drive. Well, I don't have a license. Well, we're suspending your privilege to drive. Well, folks, there's no such thing as a privilege to drive unless you possess a license. In 1973, Aberdeen versus Cole, that's the city of Aberdeen here in Washington, specifically held that license was synonymous with privilege. That since Gary Cole never had a license, Gary Cole never had a privilege. Therefore, the state could not suspend what he did not have. Now, that was a ruling that rocked the state. Because of that, the attorney, I think it was John Wolfe at the time, for some reason didn't make very good money after he got that case to be published. And he had to move from Grays Harbor County to Mason County for whatever reasons. Apparently, he's still having a hard time making it now. He's gotten a lot of trouble with the judges, and this is the truth, folks. Anytime, and I'm not saying all attorneys are bad. This guy did something good for the people. But the truth is, anytime an attorney does something good for the people, the judges and prosecutors go after them. They try to get them disbarred. I know several attorneys who told me that when standing up to the system, and I can't name them because they'll get in trouble, the bar goes after them. And what they do is they go look in their books. And if they find the attorney borrowed money out of a client's account to pay his electrical bill or his or water bill, they'll say that's unethical conduct. You're dipping into the client's funds for uses for which it wasn't specified, so we're going to disbar you. Now, what does the client care as long as the attorney is working on his case and is doing a good job, which, folks, that's kind of rare. But in this particular case, what if you got a good attorney who fell a little bit behind in his bills? Why would you care if you took the money you're paying him anyway to pay his electrical bill or water bill? It doesn't make any sense. But see, the bar does this to keep control over the attorneys, when I personally think that the government has no business knowing how much money anybody makes, or, that's none of their business. But, folks, the main thing I'm trying to get across here is they cannot suspend your driver's license for failure to pay. That's unconstitutional. That creates a debtor's prison. And by increasing the penalty after the fact, that's called an ex post facto violation. It's a bill of attainder, a bill of pains and penalties in violation of the ex post facto clauses of both the state and federal constitution. So now the lights are coming on. Woo! You're under arrest. You're placing you into custody for driving while license suspended, because the computer says. Okay, so they hired dumb cops with an 80 IQ or less. Oh, the cops said, no, cops aren't dumb. We have a college degree. Well, folks, an 8th grader in the 1800s was smarter than most college graduates today. A college graduate today could not pass a test that 8th graders took in the 1500s and to the 1800s. You can start reading about that, looking up McGuffey's Readers to find out how smart the kids were in the old days. But the cops are being mistrained to believe that they can arrest and take you into custody, because the computer says you're driving while suspended. Well, I've recently found a body of case law that says if you notify the Department of Licensing and the cops in advance that their computer's wrong, their qualified immunity goes right out the window. Normally, when you get arrested falsely based upon a fraudulent warrant that's in the computer, the cops will say, I'm just doing my job. When you go to try to sue the cop, your lawsuit against the cop's going to get dismissed because there's a statute that protects him, the good faith immunity for the good faith performance of doing his job, and that he didn't know what particular statute or constitutional section he was violating. And you guys have all heard the recent Supreme Court decision that says we can't expect the cops to know all the law. So the Supreme Court is allowing cops to intentionally not be too smart. Because, folks, think about it. If the cops were smart, and if they knew that they were violating the law, they'd write less tickets. So they hired dumb Android cops, 80 IQ or less, somebody that just left the military, usually jarheads, people that they get their kicks beating up and pushing people around and being just bullies like the high school bully. And so these cops are, I'm just doing my job. But this is a scam. The computer is false. You cannot be driving while suspended if the statute 462181 says every license expires, well, now it's 6 years, but it'd be 4 years. So how can you be driving while suspended if your license is expired? Then there's another statute, 462311 RCW, that says no license shall be suspended for a fixed period of no more than 1 year. There's a similar statute, 4604580, that also says the same thing. No driver's license shall be suspended for a fixed period of no more than 1 year. And the way the law of statutory construction works is you cannot enforce any one statute to render any other statute superfluous. You have to construe all the statutes together in pari materia relating to the same subject matter and give each statute the force and effect of law so that no statute is rendered superfluous by any other statute. Well, the cops are saying, I'm just doing my job. I don't want to hear all that mumbo-jumbo. Tell it to the judge. Now, the judges, well, you look up we have 7 million plus Washington residents. Now, let's multiply that by $40. To me, that's absolute proof that the judges have $280 million reasons to lie to you. This is proof to me that the prosecutors have $280 million to lie to you. And I'll show the judges the statute, 4625080. License, contents, classifications, endorsements, restrictions, expiration, exchange of information. Let me point out something, folks. I've read the entire motor vehicle code from 1905. That's the very first motor vehicle code, 1905. They did not have driver's licenses in 1905. They only registered the car. The original application sheets for the Secretary of State, you filled out your name, your address, the make and model and color of the car, and you paid a silver dollar to the Secretary of State. Eventually, that was delegated to the Department of Licensing, a new agency that was part of the Department of Transportation in Title 47. So now, the rest of the statute, subsection 1 of 4625080, it says the commercial driver's license must be marked commercial driver's license or CDL. Subsection A, license may be classified as follows. I, Class A. II, in parentheses, it's Class B. Triple I, in parentheses, Class C. So, folks, there's only 3 classes of driver's licenses in Washington, A, B, and C, and they're all commercial. Because I've made these arguments in courts over the last 10, 15 years, the criminally corrupt attorneys who work for the Department of Licensing in conspiracy with the Attorney General's office and the Code Revisor's office have changed the driver's license at least 4 times because of me. And I've just been told recently that they've removed the commercial class designation in violation of this statute. The old driver's licenses 10, 12, 15 years ago, on the back of the license, if you flipped it over, it said commercial classes across the top of the whole of the back of the driver's license. On the left-hand column, it clearly said Class A, Class B, and Class C. They've removed those commercial classes off the designation, off the current driver's license. They're no longer there, and they did that about 10 years ago because of me. Now, since they changed it, what did they do with it? Well, they used to, about 3, 4, or 5 years ago, if you folks pull out your old driver's licenses and look this up, you'll see it in plain sight on the front of your driver's license in very small, teeny, tiny print. It's abbreviation, CDLEND. That's the abbreviation for Commercial Driver's License Endorsement. And they've just recently removed that statute from the driver's license, and the judges will continue to lie to you and say, oh, no, Mr. Ewing, that's Chapter 4625. You have to have the license over at RCW 462001. Okay, folks, let's go look at that. RCW 462001, license required, rights and restrictions. Subsection 1 says, no person may drive a motor vehicle upon a highway in this state without first obtaining a valid driver's license issued to Washington residents under this chapter. Well, there's a problem, folks. Let's go back to 4625001, the definitions, okay? And I had a judge in Grace Harbor tell me, Mr. Ewing, that's not what the statute means. And my response was, well, Your Honor, this is what the statute says. And the case law for this state says the statutory definitions supersede and control all other definitions. You, the judge, cannot make up definitions of what the license is any more than a state can declare marriage between a man and a man. All the case law and the dictionary definition says marriage is between a man and a woman. So you can't just pass a law and say the sky is red when the sky is actually blue. Well, when we did it, we passed a law to make the sky red. So everybody's required by law to say the sky is red because I'm the judge. These judges are stupid. Okay, here's what the statute says, 4625.010. The definition set forth in this section applies throughout this chapter. Okay, subsection 3 says, commercial driver's license, CDL, means a license issued to an individual under Chapter 4620 RCW that has been endorsed in accordance with the requirements of this chapter to authorize the individual to drive a class of commercial motor vehicle. Folks, the proof that you can show the judge and say, Your Honor, I do not appreciate being lied to in court. Mr. Ewing, Louis Ewing, told me that you're a liar. And my registration in my glove box, here it is, Your Honor. Why is my car licensed as a PAS class registered vehicle? Why did Tim Eyman lie to everybody and say we have to pay $30 for tabs when the truth is we don't have to pay crap for tabs. We don't have to pay squat. The state is tricking everybody into registering their cars. That's right, folks. We do not legally have to pay 1 penny to register our car. We do not have to put tabs on our car, and we do not have to get a driver's license to drive our car. The public highways are open to the vehicular public as a matter of right, and these people are lying to you. And all you have to do is look up the statutes that I just mentioned. 4620.010, subsection 3, defines the driver's license over at 4620 as being a commercial license that authorizes the individual to drive a class of commercial motor vehicle. You can find my free flyers that lay this out on my website, lewisewing.com. LUISEWING.com. So do not let the judges lie to you. RCW 4620.001 subsection 1 is in fact in law clearly a commercial driver's license because 4620.010 subsection 3 says that so-called regular driver's license at 4620.001 subsection 1 is in fact a commercial driver's license that authorizes the individual to drive a class of commercial motor vehicle. Do not let these people lie to you. You show the judge a copy of your registration. It says, right here, Your Honor, my registration says PAS class. That's passenger class. Okay, folks, I can send you definitions, passenger vehicle. Well, you registered your car as a passenger class carrying vehicle. The state has tricked everybody into licensing all their cars basically the same as a taxi, a chauffeur, a limo, a professional truck driver. A passenger is somebody who pays somebody else money to transport them from point A to point B. There's no dictionary in the world, in the universe, that doesn't define transportation as not being commercial. Transportation is a commercial term. Driving is a commercial term. A motor vehicle is a commercial motor vehicle. And I'm going to be authoring another flyer here soon that I'm going to put it up as a download on my website, lewisewing.com. It's going to say, I am not driving a motor vehicle with Washington statutes that clearly defines a motor vehicle as being a commercial vehicle, a vehicle that is for hire. The excise tax that you pay, okay, that's what the tab. Look at your registration. Why are you paying an excise tax? Nobody reads. Everybody's too busy, okay? An excise tax is a tax on a business. So why in the hell is the state ripping us off? Okay, this is a violation of the federal RICO laws. This is a violation of the Washington State Criminal Profiteering Act. All the bar attorneys, criminally corrupt members of the Washington State Bar Association should all be charged with a criminal conspiracy of violating the Washington State Criminal Profiteering Act and also the federal RICO laws because they are defrauding the people of the state of Washington so that they can fill their pockets and get money out of us. All the attorneys are pretending to, quote, represent you in court. No, they're representing their best interest, and that's to find out how much money you got, okay? Do not fill out their financial forms when you first go to court. Okay? They're trying to find out how much money you can make, because the judges and the prosecutors are going to meet behind closed doors with your attorneys, and they're going to rig the whole court scene. Okay? They're going to tell you, they're going to figure out in advance how much jail time you're going to do, who's going to be found guilty or not guilty, whose children we're going to return, how much money we're going to make selling the children. These people are ripping us off. They are manipulating the law and misquoting the law completely out of context so that they can make money. By changing the driver's license and selling you that plastic driver's license, all the attorneys who are members of the Code Revisor's Office have committed first-degree forgery. They've also committed second-degree perjury under Washington law. And then, when they suspend your driver's license and they send you demands in the mail threatening to suspend your driver's license, including pulling your hunting license, fishing license for failure to pay child support, or whatever, they're threatening you also with contempt of court, or failure to appear will result in a warrant for your arrest for failing to appear in court when you weren't required to have that driver's license in the first place because you were not making a commercial use of the highway. Unless you are charging people who get a ride with you, passengers, unless you're charging them money for hire, you are not required to register your car as a passenger class vehicle. These people are lying to you. Every judge and every prosecutor on the bench is lying to you, and they can't prove otherwise. All the judges will say, your motion is denied, Mr. Ewing. If you don't like it, take it up on appeal. And this is the problem with our court system, folks. These attorneys are milking the cow at the public expense. So how are we going to change this? Well, I think the best way to change this, and I've got the answer, and I've been telling people this for 15, 20 years, we need to get somebody like Tim Eyman with money to sponsor a bill, and we're going to call it an act to regulate the practice of law. We're going to make it so that anybody who passes the bar exam can now go to the Department of Licensing just like any other roofer, electrical, electrician, a doctor. They can apply for a license to practice law. We need to have an elected official who's accountable to the public in charge of the bar. Right now, you folks don't know this, but the Washington State Bar Association is not part of our state government. If they were part of our state government, they would be required to have an office at the seat of government in our state capital. We would have an elected official in charge, somebody that we could vote and remove from office just like anybody else, or impeach them, or fire them. The other problem we have is we have the so-called Judicial Review Commission. That's the foxes guarding the hen house. This is the criminally corrupt judges that when you get a drunk driver judge like Bobby Bridge, who committed felony hit and run, I saw the TV reports. These people were saying she was ramming their cars and causing dents in their car, major damage to her car, trying to escape while committing felony hit and run. Okay? She was using her car as a ramming device. That's a deadly weapon. Okay? The statute says that they're self-executing. Not even required for a conviction to be handed down, okay, upon the knowledge that she's committed a felony. The statute says she's supposed to be removed from office, removed from the bench, and never allowed to serve a public office ever again. But the problem is, prosecutors are members of the same bar. They all met in conspiracy and decided not to charge her with anything. Okay? The other problem we got is Grant Anderson. Okay? This guy, a Pierce County Superior Court judge, accepted a Cadillac for making a ruling in a particular decision. He got a couple weeks off. I forget if it was with pay or without pay. Slap on the wrist. He's back on the bench. Back to business as usual. And the attorney who reported him, I can't remember his name. You guys have to Google that up about the attorney who reported Grant Anderson. That guy was up for disbarment. See, because apparently our Washington State Bar Association is so criminally corrupt and so morally debased and dishonest, they consider it unethical for an attorney to report a judge committing a felony crime. It's time to take down the State Bar Association. It's time to sponsor a quo warranto to dissolve the Washington State Bar Association. We need an act to regulate the practice law. And we could put all the bells and whistles on that law where if we want to disbar an attorney, no. We are not going to go to the State Bar Association unauthorized practice of law board or they call it their disciplinary board. Again, it's the foxes guarding the hen house, attorneys who are members of the bar judging themselves. These people are incapable of monitoring themselves. They're incapable, incompetent, and intentionally so. It's Peter's principle at the highest. The higher the level of incompetency, the higher that you will get promoted in the job. This is why we have dummies like Assistant Attorney General Peter Kay, who works in the Kitsap County Superior Courts, the family courts, helping people steal children. He knowingly solicits CPS social workers to commit perjury. Judge Hall in Kitsap County Superior Court knowingly allows CPS social workers to commit perjury in court. You folks are going to love this. Judge Hall is swearing in CPS social worker Paige Cummings to testify in my case, and I said, I object, Your Honor. And the judge said, Mr. Ewing, you're going to have to wait till I'm done swearing in Ms. Cummings. What are you objecting to? I said, I object to you committing a fraud upon this court, sir. What are you talking about, Mr. Ewing? Your Honor, the United States Supreme Court, in a case called Bledsoe versus LaHue, specifically held that police officers have immunity for committing perjury under oath in open court on the stand after being sworn in. And so I know for a fact that you're perpetrating a fraud upon this courtroom. Period. By pretending to swear in Paige Cummings. And Paige Cummings standing, you're raising your right hand, and you're having Paige Cummings sworn in. And she knows, all the social workers, they know that they have immunity for committing perjury in open court. Okay? I've got a problem with that. Her testimony is no good, so I moved that all her testimony be stricken or that she not be allowed to testify. Your motion is denied, Mr. Ewing. Oh, Your Honor, well, I'll stipulate for the record, if you stipulate for the record that you're not going to allow her to have immunity for committing perjury in your courtroom, I won't object to her testimony. Will you do that, Your Honor? Will you make a ruling? Will you make a statement on the record that you're not going to allow Ms. Cummings to have immunity for committing perjury in this courtroom? You know what Judge Hull said? I'm not going to do that. And he ran out of the courtroom all flustered because I busted him. He's a criminal. Judge Hull is a criminal. All the family court judges in Kitsap County, and I wouldn't be surprised if all the family court judges in all 39 counties. I'm going to read you the proof of this, folks. It's right in the statute. 2644060 RCW. Immunity from civil or criminal liability. Confidential communications not violated. Actions against state not affected. False report penalty. 1A. Except as provided in subsection B of this subsection, any person participating in good faith in the making of a report pursuant to this chapter or testifying as to alleged child abuse or neglect in a judicial proceeding shall in doing be immune from any liability arising out of such reporting or testifying under any law of this state or its political subdivision. The case law, Gilliam versus DSHS, folks, this is a Washington case. 89 Washington Appellate, page 569 at 580 to 581, or 950 Pacific Second Reporter, page 20, January 26, 1998. You're gonna love these cases, folks. When extended to judges, prosecutors, grand jurors, witnesses, and others who perform official functions in the judicial phase of a proceeding, absolute immunity protects the nature of the judicial proceeding itself, citing Bledsoe versus LaHue, 460 United States Supreme Court Reporter, page 325 at 334. Or 103 Supreme Court Reporter, page 1108, or 75 Limited Edition Second, page 96, 1983. The reasons for this rule are also substantial. It is precisely the function of a judicial proceeding to determine where the truth lies. The ability of court under carefully developed procedures to separate truth from falsity and the importance of accurately resolving factual disputes in criminal and civil cases are such that those involved in judicial proceedings should be given every encouragement to make a full disclosure of all pertinent information within their knowledge. Quoting Imber versus Pacton. Okay? Toller versus Paulson in the California case says, witnesses are immune from civil liability under Section 1983, Title 42, based on their testimony in judicial proceedings, again citing Bledsoe versus LaHue. This immunity extends to sworn statements made to the court. Citing Burns versus King County. Guess what, folks? Burns versus King County was was a social worker. Okay? In another case involving similar circumstances, the Sixth Circuit also held state social workers absolutely immune from Section 1983 actions resulting from the initiation of judicial proceedings, citing Kurzawa versus Miller, 732 Federal 2nd Reporter, page 1456, Sixth Circuit, 1984. The court rested its holdings on the decisions of the Supreme Court in Imbler, Butts, and Briscoe versus LaHue. This is Vosberg versus Department of Social Services, 884 Federal 2nd, page 133 at 137, 4th Circuit, 1989. Here's another case. It talks about the guardian ad litems. In addition, the guardian ad litems, therapist, and attorney have absolute immunity for any damage claims based on the functions of testifying before the family court. See Briscoe versus LaHue, holding that witnesses and other persons who were integral parts of the judicial process are entitled to absolute immunity. Folks, these brainless bimbo social workers that work for the CPS division of DSHS in Washington are getting paid to commit perjury on a daily basis. And the judges, by standing up the social workers and pretending to swear them in, are committing subordination of perjury. They are soliciting the social workers to knowingly commit perjury. And I'm going to tell you something. These people are so desperate to not win a case, to not lose a case against a pro se litigant named Louis Ewing. Judge Hall, Assistant Attorney General, Peter Kay, in my personal opinion, had a criminal conspiracy to get Paige Cummings to testify that Louis Ewing asked if she liked being tied up and raped. Yes. That's how low these scum people are. CPS social worker Paige Cummings, a lying biatch, testified in court that I asked her if she liked being tied up and raped. Well, I proved that was false. I asked her, well, Miss Cummings, when I allegedly asked you this question, did you report this to anybody? Yes, I did. Did you call 911? She says, no, I didn't. I said, well, Miss Cummings, why wouldn't you call 911? Well, Mr. Ewing, I knew that you're upset about losing your children. Well, Miss Cummings, asking somebody or threatening to tie somebody up and rape them, or asking them if they like being tied up and raped, that's a very serious offense. Don't you think so? Well, yes. And why didn't you call 911? Well, Mr. Ewing, I knew you were upset. Well, did you call the sheriff? And she goes, yes, I did. Oh, the sheriff's name. She says, Detective Aaron Baker. Did you tell about Rudy, the security guard that works at the CPS office right there in Kitsap County in Bremerton? She goes, yes, I told Rudy. Did you tell your supervisor? She goes, yes. Did you tell any of your coworkers? Yes, I did. She goes, and I said, what's their names? And she goes, I don't recall. Well, folks, that's a sign right there. When somebody says, I don't recall, you know they're lying. So right away at the end of court that day, I ran down to the CPS social worker office and talked to Rudy, the security guard, and asked him, Rudy, do you remember me? And he goes, yeah. I said, do you remember when I used to come here, did I always sit in this chair? Which chair to sit in? He pointed to the very chair, the very front of the office, closest to the front reception window, closest to the front door so I could see the kids coming to visit. And keep in mind, folks, my children were not removed from my custody. Okay? My children are not in custody in CPS right now through any fault of my own. My ex-girlfriend and I were separated for more than 2 years. I was the innocent parent at home minding my own business. Okay? My ex-girlfriend, who, folks, I made this mistake of falling in love with a stripper. She was a drug addict. She absconded with the children without my permission, without my knowledge. I had to spend over $4,000 on a private detective to find out even where she lived because she was not allowing me to see the children. I had friends testify in court. She told them she was never going to let me see the children. She kept them from me. Okay, so, you know, that hurts my feelings, you know, missing my sons. But then I find out she gets arrested and taken into custody for allegedly driving a stolen truck. The Kitsap County Sheriff's committed a false charge against her. As it turns out, the truck was loaned to her by her stepfather, Roger Gavel. The cops conducted an illegal search and seizure and ran a check on the license plates when they couldn't see the license plate on the front because the license plate in the front was missing on a truck she was driving. The cops committed an illegal search and seizure in running a check on the electronic mobile data terminal, which is illegal. Okay, the penalty for the civil infractions under RCW law says when the front license plate's missing, the statute specifically says the officer is limited to issuing the green citation and leaving a copy with the person or a copy on the windshield. There's nothing in that statute that allows them to run a computer check for a warrant. Then, when I pointed that out, the Assistant Attorney General, trying to escape out of his first lie, says, well, Mrs. West was arrested on a warrant in King County. Well, folks, Attorney General Peter Kay is a liar who misstates the truth. The truth was her so-called warrant in King County was 8-9 years old. That warrant was expired for more than 7 years. The prosecutor in King County, who issued a warrant originally for Catherine West, did not go in and renew that warrant before the end of the year. That violates another case called State versus Clump, which cites the specific statute of limitations that says no misdemeanor shall be prosecuted beyond 1 year. But that's besides the point, folks. They had no authority to conduct a warrant check in the first place. Now, I read this to Judge Hall in open court, and it was funny. It was funny embarrassing these people. I out-debated all these people. I had a copy of the judge's bench manual. Keep in mind how funny this is, folks. I have a copy of every judge's bench manual in this state. I have the Superior Court judge's bench book. I have the Courts of Limited Jurisdiction bench book. I have the Court's DUI bench book. I even have their insane album, the one that says for mentally insane people or whatever. I think it's the courts that are criminally insane. Okay, I have their bench manuals for all this. So here I am in open court. It says, Your Honor, it says right here in the judge's bench manual, if it's discovered that the car that was borrowed from a friend or a relative, it says the judge shall dismiss the charges. You guys had no business asking Catherine West to plead guilty to possession of a stolen vehicle when you guys know for a fact that that car was borrowed from her stepfather, Roger Gavel. Your attorney, public defender, or public pretender, as you folks like to call them, he failed to inform Catherine West of this case law. He failed to tell her of all her options. He failed to tell her, well, you know, under State versus Latson, Miss West, this is a pretextual stop. But, oh, folks, another thing they're not telling you, she wasn't legally driving. Her car that she was allegedly driving was legally parked. It was not running. The keys were not in ignition. When the cops came into Horseshoe Park in Kitsap County, she was cooking steaks on a barbecue for her sons. Okay? And she was legally parked. Now, keep in mind, it's 3:30 in the morning, and yes, it may look strange for a woman to be cooking a barbecue at 3:30 in the morning, but isn't that what a good mother does when her children are hungry, is that she would cook them something to eat? Okay? She was in a public park where she legally had a right to be, and it was not closed. There are no hours posted on this particular park at the front gate or the rear gate. I took pictures of it. I got proof of it. There's no public hours parked, but she was actually parked out in front of the park on a parking strip where she was legally parked. And just because she had no license plate and she's outdoors at 3:30 in the morning cooking steaks, does that look like criminal activity? Does that give a cop in Kitsap County? Is that so stupid the cops are in Kitsap County? They just are so desperate to write tickets that if they see somebody, oh, look, there's a lady over there. She's cooking steaks. That looks like a crime. Let's check her out. They don't see the license plate in the front. They run the license plate check on the back. That was illegal, folks. The cops do not have the legal statutory authority to run a criminal background check or a warrant check. Okay? They're going to now some attorney is probably going to call in and complain and say that's not true. Well, the attorney doesn't understand the law and he doesn't read it. State versus Rife is a case which amended the statute that allowed a jaywalker. The Supreme Court overturned it, and Kurt Reagan is actually the guy who first wrote the briefs for State versus Rife. And Governor Locke, a Chinese man, the former governor of our state, being the criminal, corrupt government he is, proved that we don't have a judicial branch. Okay? We don't have a judicial branch that's independent of the executive branch. Okay? The executive controls. Governor Locke went on TV and said to all the cops to ignore the Washington State Supreme Court ruling that ruled the police officers didn't have authority to run a statutory background check on the guy who was jaywalking in State versus Rife. He told the cops to keep on running checks. Governor Locke convened an emergency special session of the legislature to amend the statute to now allow the cops to run background checks on the license plates. Well, guess what, folks? That was passed during an emergency special session under RCW 34, the Administrative Procedures Act. The Administrative Procedures Act specifically says any act that's passed during an emergency special session expires in 120 days unless it's passed at the next regular session. Well, guess what, folks? That statute was never passed at the next regular session. That means the so-called amendment to 4620, I'll have to look it up, 4620-060, or 4620-0, I can't remember, 4620-061 or 060, somewhere in there. You'll have to send me a request on email. My email, rcwcodebuster@aol.com or yahoo.com and gmail.com, and I'll send you the State Rife site for anybody who wants to read it. But State versus Rife has legally expired. And subsequent to that, we have two Washington State Supreme Court decisions. And I told Judge Hull this in open court. Okay? He doesn't care about the law. See, the judges have no honor for the law. State versus Duncan and State versus Day. Back-to-back, two Washington State Supreme Court decisions. Says police officers cannot apply Terry principles to a civil infraction. No matter what the civil infraction is, they cannot conduct a Terry stop. But see, Terry stop only applies to somebody who's driving. Catherine West was legally parked. The car was not running. There was no keys in the ignition. She was not even in the vehicle. She was standing outside barbecuing steaks. So they cannot use this statute that allows cops to run criminal background checks. It was completely an illegal search and seizure in violation of Article 1, Section 7. Catherine West, public defender, is grossly incompetent. And what's even more grossly incompetent is Judge Hull not appointing my two sons, Lewis West and Phoenix West, counsel. And when I objected to that, I've got three sons, Miles Tejano, Lewis West, and Phoenix West. All the attorneys in the courtroom, Judge Hull, and Assistant Attorney General Peter Cade lied to me and said there's no attorneys for children under 12. Only children 12 and over get attorneys. There's no money for it. The legislature hasn't approved it. Okay, well, I know I'm being lied to. Okay, and family court's in my new bailiwick. Okay, it's not really my bailiwick. My specialty is criminal law. I help people beat IRS charges, drug trafficking, cocaine, methamphetamine charges. I help people with drunk driving charges, driving while suspended charges. My area forte is not really family law. But guess what, folks? For the last 2 years, I've had to bone up on family law. And I am very, very quickly becoming an expert in family law and discovered that these people lied to me. And the proof that Judge Hull, Assistant Attorney General Peter Kay, and all the attorneys lied to me in the courtroom about my children not being able to apply for counsel was the fact that I put in a motion. I did the research on through the statutes and the court rules and found out they lied to me because the statutes and court rules specifically allows for counsel if somebody asked that counsel be appointed. And I didn't know that at the time. So my children got screwed out of counsel at dependency. And they tried to say I couldn't represent my children because I might be one of the bad parents. Okay? These people conspired from the very beginning not to give me my children back. Okay? This is laughable at best if it wasn't, but it's not funny. I was first contacted by a CPS social worker, Lisa Sinnott, who, by the way, Judge Hull did not allow me to subpoena Lisa Sinnott in violation of the confrontation clauses of both the state and federal constitution. He did not allow me to subpoena the arresting officer, Kitsap County Sheriff, the incompetent, criminally corrupt Todd C. Byers. Todd C. Byers, I'm going to sue you. Lisa Sinnott, I'm going to sue you. Judge Hull, I'm going to sue you. Assistant Attorney General Peter Kay, I'm going to send all you people to prison. You guys messed with the wrong guy. I'm a guy who knows the law, and you guys think you can conspire and work things against me. Here's what they're hoping. They're hoping to trip me out on appeal, hoping I screw my appeal. Well, the proof that they lied was when I put in that motion for attorneys to be assigned at termination. Well, lo and behold, Judge Hull all of a sudden The clouds part. God comes out from the sky and tells Judge Hull and Eric, well, he put in the right motion, Judge Hull. You got to be honest now and grant the counsel. Well, all of a sudden, Judge Hull magically became honest and granted my motion. All of a sudden, Little Lewis West and Phoenix West, okay, and the reason why their last name's West instead of Ewing is because of Catherine West. She absconded with the children, and I got my children out of the hospital with no birth certificate, no vaccinations, whatever. The state's all pissed off that I got my children out of the hospital with no vaccinations and not even telling the hospital their names. I said, it's none of your business what we're going to name them. And I got them out of the hospital with no vaccinations, no birth certificates. So CPS's excuse for not giving me the children was, well, Mr. Ewing, we have no proof you're the father because you're not legally married, and we need you to take a DNA test. And at first they were denying me to take the DNA test because I wouldn't give them my social security number and I wouldn't give them an ID. I told them I don't have to have a state ID. I haven't had a state ID in probably 20 years. Okay? That's been expired. The last ID I had, folks, no, that's not 20 years. 1996, I was on a boat working for a boat called the Bristol Storm. It's owned by a maritime attorney in Seattle, very well-known, respected attorney, Anthony Uri. Him and I are good buddies, actually. I worked on his boat. Well, the Bristol Storm sank in Bristol Bay. All my IDs, passport, everything that I had for ID sank. And at that time, I actually tried to go renew my IDs. Nobody would renew my IDs because I didn't have any ID to prove who I was. So I was unable to get a state ID or a driver's license if I wanted one. But, folks, I would never get a driver's license again. I haven't had one since 1996. So their excuse was, so I had to write a brief showing that they were committing felony crimes because the statute says it's a felony to require or demand a Social Security or deny me any benefit or privilege. And I had case law in my motions stating that I could make up any name I wanted to, whatever my name was, Louis Ewing. If I decide to make up my name Louis Presley or Elvis Presley, and I make up a name, as long as I'm not using my name for unlawful purposes such as check kiting or identity theft, using somebody else's credit card, I can make my name whatever it is. I don't have to show ID. I got Washington case law, folks, Barwick, State versus Barwick, that says inside the continental United States, an American citizen isn't required to have any ID on his person whatsoever. So they granted my motion and allowed me to take the blood test, the DNA blood test. They stalled for 2 months. 2 months. All of a sudden, 2 months later, oh, Mr. Ewing, this is Peter K. Well, apparently, the blood test is positive. Phoenix and Lewis West are your sons. But we have to wait for the mother's blood test. And I go, what? I don't care about the mother's blood test. The blood test says those boys are mine. You got to hand them over. Oh, Mr. Ewing, we can't do that. Okay, folks, this is 2 months later. We can't do that. We have to wait for Catherine West's blood test. Peter K. lied to me. I found out later from Catherine West her blood test took 2 weeks. I've called several laboratories around Seattle, and they said it only takes 72 hours for a DNA test. They were required by law to make a disposition of the finding of dependency within 14 days of June 25th, 2012. That's right, folks. I'm fighting CPS for my children. They're pissed off because I beat them the last time. Catherine West, when my firstborn son was born 7 years ago at the Good Samaritan Hospital, she tested positive for cocaine, ecstasy, methamphetamines, marijuana, and Percocets. My son tested clean. Well, they just couldn't believe it because we just know that this girl looks like a rocker. She's on drugs, so there's got to be some drugs. So they sent off a stool sample from Little Lewis West to a second outside laboratory, and lo and behold, all of a sudden, Little Lewis West all of a sudden tests positive for minute trace elements of methamphetamines, which is total BS. All the nurses said, my boy showed no sign of drug addiction. He was born very healthy, 10.5-pound boy. Nothing wrong with him. No breathing problems, no nothing. He was perfectly healthy. Well, they placed him under arrest and wouldn't let us leave the hospital with him. And they took him down to a PIC facility. Now, folks, PIC facilities is part of the criminal conspiracy, and I believe that they're probably owned by a corporation, which is in turn owned by an LLC or a trust based in California. which I bet if we do some research, we're going to find out the judges probably own all the PIC facilities. They make $150,000 to $200,000 selling babies. And the nurses told us, oh, no, when a baby tests positive, I said, why is there electronic gates here and break-proof glass on the hospital birthing center? Well, that's to make sure that nobody kidnapped the babies. And I go, really? You've had babies kidnapped here? Well, yeah, when the parents tried to take the baby, we stopped them. I go, excuse me? How can parents kidnap babies when the baby's theirs? Oh, no. When that baby tests positive for drugs, it's ours. Okay, this is BS, folks. This is a lie. You go to my website, ultimateusers.com. You could download free flyers. I show the state statute and federal statute that says everybody. Now, keep in mind, folks, I'm not promoting drug use, okay? But I wrote the flyer for marijuana. But if you look at the statute, in my flyer, 6950-302 subsection 3, C3, the following persons need not register and may lawfully possess controlled substances under this chapter. Subsection 3 says an ultimate user, or in a long story, tells you a person with a written authorization. That would be somebody with like a medical marijuana prescription or any other prescription drug. An ultimate user is defined in another statute, 6950-101BB, means an individual who uses the controlled substance for their own individual, and personal use, comma, administration to a member of their family or household, comma, or for administration to an animal or a pet owned by you. That's right, folks. Washington statute says you have the right to get your dogs and cats stoned if you want to. Okay, your baby is obviously a member of your household, but guess what, folks? It's illegal for the hospital to take drug tests of the babies. The CPS has a secret unwritten policy of testing mothers without their consent, without their knowledge, of all mothers who don't get prenatal care. Well, Catherine West had no need to have prenatal care. She's already had 2 healthy daughters before then. She knows how to take care of a baby. Actually had her on Manatech vitamins, which all the doctors will tell you Manatech vitamins are better, far better than most of the prenatal vitamins out there. Manatech vitamins are great for women who want to have a healthy baby. Also, I had her on Amber Toast, which is another product put out by Manatech that helps women who have problems with miscarriages keep their baby and hold on to their baby. Well, needless to say, after 2, they didn't realize who they were screwing with when they took Catherine West babies, because me and Catherine weren't, legally married, okay? As soon as they find out who I was, and I started hitting them with a bunch of paperwork, 2.5 weeks later, I get a call from the Attorney General's office. Mr. Ewing, we made arrangements for you to pick up your baby boy tomorrow at 10:30 tomorrow morning. Is that okay?
It's pretty sparse, but here's my cell phone number. Is 206-898-1134. Interview SILVANA Washington 98287. How's just? That's it. It's a grocery store with a dispensary. In a red light was my mind, all my love zoomed